It's really a pleasure to see all of you and to be communicating with you. What I want to do today is to talk just a little bit about intergenerational equity as a legal principle, and then to turn to the most recent development, which is the ICJ advisory opinion, and to go through it a bit so we really understand more fully what has happened, and then to turn briefly to the advisory opinions by the Inter-American Court of Human Rights, and then reference other courts of human rights. The basic concept of intergenerational equity is that all generations, past, present, and future, are partners in caring for and using the earth, but are partners in humanity. And as the ICJ advisory opinion said, that we are trustees of humanity for a dignified life. The notion there behind intergenerational equity actually has deep roots. It has deep roots in diverse cultural and religious traditions, the Judeo-Christian tradition, Islamic law, other religion traditions, indigenous peoples, customary laws in Africa and other areas. And I think it's also primordial social value with deep biological roots. In international law, we turn to the traditions of using principles of equity. On the one hand, to interpret legal principles and instruments in order to reach decisions that are just, and as a basis for standards to allocate and share resources. And that can be applied much more broadly to other areas other than the earth. We've had a number of developments in the past of references, certainly by the International Court of Justice, to future generations, and in human rights courts and other international bodies. What I want to do today is to turn to the July 2025 advisory opinion of the International Court of Justice responding to the request of the United Nations General Assembly. And the first thing to note about it is it was a unanimous advisory opinion. And that's a very important statement. And I want to repeat it. It was unanimous. And what it did has a number of significant points. And the first is that it integrated international law for climate change to include both the treaties and international agreements and the rules of customary international law. What this means is that there's state responsibility under customary international law, even if the state is not a party to the international agreement and beyond what the international agreement says. The court then also looked at what the obligation was, and there's an obligation there of due diligence. And I want to stress that it's due diligence as a standard, but it's strict due diligence. And the question is, what are the obligations? And two of them are flagged. One is the obligation to prevent harm, and the other is an obligation to cooperate. And both of these in the implementation then are subject to the principle of due diligence, of really strict due diligence. I want to reference very briefly an issue that is very striking in the court's opinion, and that is their resort to and reliance upon scientific assessments of climate change. And there's considerable quoting of a reference to the Intergovernmental Panel on Climate Change, the IPCC. Now, the question there is on the science of how do you do a risk of significant harm? How do you assess that? And in paragraph 283 of the court opinion, it says that due diligence also requires states to actively pursue the scientific information necessary for them to assess the probability and seriousness of the harm in conformity with the common but differentiated responsibilities and respective capabilities principle. And paragraph 284 goes on there to say the standards of due diligence may also become more demanding in the light of new scientific or technological knowledge. In other words, taking account of the fact that what we know about climate change will change as we go forward. And both of these paragraphs, I think, are very important for climate change, but can also be applied in other areas that we are concerned about. Okay. The question then is, does this apply? That's what I've said, apply to all the obligation to prevent harm, the obligation to cooperate. As we go forward, do they apply to everyone? And one of the very significant statements there is that the obligations are omnia ergo omnes. And ergo omnes means that they apply to everyone. And the basis for this is that climate is a common concern of humankind. And this definition of it is important because we have to ask ourselves, well, this would all other environmental issues, other environmental natural resource issues also potentially be included in this as a common concern of humankind, and the application then of the principles of ergo omnes. Now I turn to the question of intergenerational equity, which is addressed in a section in the ICJ advisory opinion. And this is significant because it is the first time that the International Court of Justice has actually accepted and dealt with intergenerational equity. I repeat, this is the first time that they've had a statement about a principle of intergenerational equity. And so if we look at the question of intergenerational equity, we turn to the section that identifies a half dozen principles of international law that apply to climate change. And there's a section there that identifies intergenerational equity as such a principle. Paragraph 156 says that intergenerational equity is an expression of the idea that present generations are trustees of humanity, tasked with preserving dignified living conditions and transmitting them to future generations. And now the question is, so what is the significance of this? And in the court's view, the significance is that it stems from a principle that stems from equity considerations. And the court explicitly says that intergenerational equity is a manifestation of equity in the general sense, and thus shares its legal significance as a guide for the interpretation of applicable rules. It goes on further later to say, due regard for the interests of future generations and the long-term implications of conduct are equitable considerations that need to be taken into account where states contemplate, decide on, and implement policies and measures in fulfillment of their obligations under the relevant treaties and customary international law. And I want to pause here to distinguish, the court doesn't say it's a separate independent principle that would be like customary international law that can be relied upon. But it does say, importantly, that it can be used to consider, decide on, implement policies and measures, interpret the existing laws and agreements. And that's a very important opening, and I think we may want further consideration on that, because that could apply across the board. And that's a very important statement on that point. Okay. Now, the court does deal with the question of what are the legal consequences that arise from violations of state responsibility for unlawful acts. And for those, it cites to the existing consequences for states for violating state responsibility for unlawful acts. Now, let me move on just to highlight a couple of other things. And the first thing I want to highlight is that there have been other important advisory opinions that have adopted or recognized, let me put it that way, recognized intergenerational equity, including the including the advisory opinion before the Inter-American Court on Human Rights in May 2025, and a couple of previous ones, the European Court of Human Rights, and there is currently, as we know, the request for an advisory opinion before the African Court of Human and People's Rights, but that's still in progress. So we will have to see what happens there. And finally, there have been a number of national court decisions related to intergenerational equity, many of them having to do with climate, but there's also important ones that have had to do with mineral resources, particularly coming out of the Supreme Court in India, pollution cases, and other natural resources cases. You're talking about dozens here, dozens and dozens that have come up since the year 2000 on this point. And with this, I'd like to pause because I know that there are two other presentations and we want to have time for discussion. Thank you very much. And thank you for giving me the opportunity.
Thank you very much, Edith. And I think that was a very, very important overview that you did. And I think starting with the global picture and what happened through this advisory opinion on climate change and the breakthrough about the interpretation of the intergenerational equity principle is very important. And now I want to deep dive a little bit on how it has impact and how it could further impact national implementation and national law. And I would like to give the floor now to Alina and Aishwarya for a presentation on climate law frameworks and explain to us how as well this advisory opinion could either accelerate and what opportunities it presents for these framework laws.
Thank you so much. Hello, everyone. This is a great opportunity to share research in this area. So what we're going to do in the next few minutes is talk about how national framework climate change laws, which is an overarching legislation that most countries rely on in setting long-term national frameworks to deal with climate challenges. So what do we learn from our research on do those laws actually make impact on addressing key failures in the climate governance? And then we will also share the ongoing research on specific understanding, do those framework laws actually explicitly address the rights of future generation? And then we'll make a bridge to how advisory opinions might have an impact on those processes. So next, please, Aish. So basically, what we are doing at the moment at the Grantham Research Institute is looking at several national climate change acts, the framework pieces of legislation, and going through very detailed qualitative research involving interviews with a wide range of actors, including private sector, civil society, academic institutions, but also government, different parts of government, and journalists who write on climate issues to understand how those legislations are playing out in terms of their impacts. And at the moment, we have completed studies on the UK Climate Change Act, which is the landmark legislation that serves as the model for many national climate laws. And it has been in place since 2008. And we've also looked at Germany, Ireland, and New Zealand. Those studies are available and published. And currently, we are undertaking similar research in Chile and South Africa. So what do we learn? Next, please, Aish. What we learned from the completed research is that framework climate change laws do deliver on the main expectation of addressing key failures in national climate governance, namely dealing with short-term electoral cycles and then bringing the long-term perspective into the policymaking. Over 70% of our interviewees across all of the countries actually, without being prompted, noted impacts on strengthening climate governance and in particular bringing this long-term foresight thinking into policymaking as one of the main observed impacts of climate change laws. We also looked at what are the specific areas where national climate governance has been strengthened through national climate laws. And those major three areas were increasing and kind of promoting the whole of government response to the climate change, helping break through silos across the sectoral ministries and also across the level of governance, such as national, subnational, and municipal level. We also, in particular, if we look at the key provisions in the laws that ensure that this is actually happening, as well as the bringing this long-term perspective in the whole of government response, these are provisions related to targets, long-term targets, mostly to 2050. Oftentimes, this would be net zero target or climate neutrality target integrated into the climate law, but increasingly, it's also climate resilience target, ensuring resilience of the society, which are then in more detailed laws are backed up by intermediate targets such as carbon budgets or other ways to get to the long-term objective. The other key provision we found is the requirement to mainstream climate considerations into decisions by government, and also an obligation set on the ministry responsible for climate action, but also on the key sectoral ministries to create both cross-cutting multi-sectoral climate change plans, but also specific sectoral policies to ensure implementation of the targets. The second area where we see clear impact of the national climate laws is in terms of strengthening accountability for climate action. And again, that relates both to interdepartmental accountability once you have a clear targets and reporting requirements and timelines to meet them. That has really led to greater accountability. But also having climate law clearly provides stronger basis for climate litigation. And actually in all of the countries we have looked at, there have already been national climate litigation cases, which in many of those have actually led to amendments and more ambitious climate laws as a result of that. And this is where we see a clear link with the advisory opinions. While we don't expect and the international legal requirements do not immediately translate into national climate laws in most of the countries, the expectation is that those advisory opinions would provide a stronger case for national climate litigation, which combined with existing legal frameworks would actually allow for legal action that could lead to more ambitious outcomes. And the last area where we see clear positive impacts is on just and inclusive transition, which is again the area where many countries in their climate laws link to the principles of equity that Edith has talked about. So sometimes it's in the preamble or in the key principles of the legislation, but we are also seeing increasing number of laws with operational provisions which require the government to establish just transition strategies or funding mechanisms that go beyond just compensating labor force, which is negatively affected by climate action, but actually now goes beyond to consider equity considerations in the climate response and also related to climate impacts more broadly. Next, please, Ayush. Just very briefly, how different key elements of climate laws that I've mentioned create those impacts, in particular thinking about this long-term vision that we're interested in this group. So I think climate targets is the element where most countries see the direct entry to including this long-term objective. So obviously it sends a long-term signal both to the government but also to private sector and to investors. They provide political accountability, and once you have a 2050 long-term target, it makes it easier to assess progress and to hold the government accountable. We can come to that in the discussion if there are questions, but there are already some examples. For example, in the UK, when the government few years ago renegated on some of the policies that ensure the achievement of 2050 target, that shift and clear gap between the target and what the government was proposing to do was used by a number of actors, including independent advisory body, to push for more ambitious action. And targets also ensure engagement across the board from different ministries and improve coordination. Next, please, Ayush. A very important element is this requirement for objectives integrated into climate laws to actually be included in all decisions by public sector bodies. And we see great variety in how that language is structured, which then translates in very different impact in terms of mainstreaming of climate objectives into decisions by government. And the best example we have seen is the Irish law, which has the strongest language, which says that the government across the board has to take decisions in a manner which are consistent with targets and also key objectives and plans which are put on, which are developed underneath the law. And there have been examples where major infrastructure decisions actually have been rejected based on not meeting this this objective. Next, please. The other key element which I wanted to highlight, which particularly is noted as an institution that helps ensure this foresight and long-term objectives in the national climate governance, are the independent climate advisory bodies, which again, UK was the first one, but now we have quite a lot of those bodies across Europe and globally. The idea is that it's an independent body composed of experts which are appointed based on their expertise, not representing any political constituencies. And therefore, the law then requires them to have an independent role in advising the government on the long-term targets, on intermediate targets to meet them, but also to undertake independent assessment in many cases, in many countries, of progress in implementing the climate law. And you can see at the bottom the key design elements that ensure effectiveness of those bodies. They need to be independent, they need to have high level of expertise, clear mandate and resources. And importantly, they are most effective when the government has a clear obligation to respond to the advice they provide and integrated into legislation. Next, please. Over to you.
Yeah, so I just this is a piece of research that we conducted recently. It's not published. I think it will be published later in the year as part of a report that we're producing with International IDEA on provisions on institutions for future generations. But what we did was we undertook a review of references to future generations or future generations like ish terms that come up in climate framework laws to see if they kind of explicitly provide for future generations. So as part of this, we reviewed 72 climate framework laws that are identified through the Climate Change Laws of the World database, which is maintained by colleagues here at LSE. And we searched for a number of terms, and these terms were kind of developed in collaboration with people working on future generations and kind of bottom up, depending on what we could actually see in the documents. And we came up with several kind of indicators of provisions for future generations. So things like principal level commitments to future generations, or commitments to precautionary principles, long-term plans or actions for future generations, principles, plans or actions to care for young people or children, principles, plans or action to educate or empower young people or children, principal level commitments to sustainable development, and plans or actions for sustainable development. And in this, we found that by far the most kind of common reference or provision for future generations was long-term plans or actions. This which came up in 51, like over 50% of the climate framework laws, although they didn't generally explicitly say that it was for future generations, they were largely for the long term or the future. And we see that there are actually very few kind of tangible long-term plans or actions like for
very few long-term plans or actions for future generations. And as part of the review, we also kind of captured any institutional provisions or innovations for future generations, the long-term sustainable development, children or youth. And this included the creation of bodies with a mandate relating to future generations, the expansion of the mandate of bodies to cover future generations, and explicit confirmation of the mandate of existing bodies to cover future generations. And in this, no institutional provisions or innovations explicitly focused on future generations came up in the searches, but we did find a lot more kind of focused on the long-term sustainable development or children. So as I said, this will be published later in the year, but this is to kind of give you a snapshot of some of the findings that we get.
So just to conclude, I think what this work clearly shows that climate framework laws and processes set up to implement them clearly present a tangible opportunity to secure foresight and also indirectly the rights of future generations. We see that the key provisions on the climate change laws already strengthen long-term governance. However, the law itself is not enough, and that's also a finding of our research. There needs to be sustained political commitment and pressure from civil society and other actors to ensure implementation and no policy reversal. And the impacts are also created not just by the direct provisions, but indirectly through strengthened institutional capacity for the implementation of climate laws, subsidiary legislation and regulation, signals to investment, campaigning around implementation, and importantly, litigation relating to the law. And that's where we expect particularly the impact of advisory opinions that Edith presented to start coming through in the next years. Thank you so much for your attention.
Thank you very much, Alina. Thank you very much, Aish. This was a very comprehensive presentation, and we're very grateful for the snapshots as well of your future research, which was a very nice complement to Edith's presentation and a very nice transition to the presentation of Woo Jung from the Korea Advanced Institute of Science and Technology. Actually, one of the best cases, I think, of climate litigation linked to specific climate targets, and a government comes from South Korea, and this is the moment for us to do a nice deep dive. So very grateful that you can join us at a very late time again, Woo Jung, and the floor is yours.
Thank you very much. Can I share my slides?
Yes, please go ahead. Normally you have sharing
Select the tab.
if you can't, I can do it because I do have your PowerPoint presentation.
Okay, thanks so much.
Would you like me to do it then?
Yeah, I can do that.
Okay.
Yeah, it's okay.
Yeah, of course. And
Oh,
yeah,
thanks so
okay,
much.
we can see that.
Yeah.
And just in the meantime,
Yeah.
acknowledging our new colleague Tianhan that has just joined us as well from Tsinghua University. We're very grateful that you can join us as well, and thank you. I know it's a little bit late by you, but yeah, again, very grateful. And the meeting is recorded, so you'll have the opportunity to listen to the first part of the very interesting presentations. Woo Jung, the floor is yours. Sorry.
Thank you very much. Thank you. Good morning, good afternoon, and good evening. My name is Woo Jung Jeon. I'm an associate professor at KAIST, Korea Advanced Institute of Science and Technology. I want to begin by thanking DAOIA and the UNU Center for Policy Research for this generous invitation and for assembling such a distinguished group. My presentation today examines South Korea's Constitutional Court decision of 29th August 2024, about 2 years ago, Asia's the first constitutional climate case, and its implications for the operationalization of state duties to future generations. I will structure my 10 minutes around 3 questions that are, I think, especially relevant for this forum. First, what exactly did the Korean Constitutional Court decide? And why does it matter for constitutional climate jurisprudence? Second, what were the conditions that made this litigation succeed? The factors that moved the case from a plausible claim to a unanimous finding of unconstitutionality. And third, what concrete lessons does the decision offer for those of us working on the implementation of state duties to future generations, including the context of the ICJ advisory opinion? Between 2020 and 2023, 4 groups of petitioners filed consolidated constitutional complaints against the South Korean government. The petitioners were deliberately diverse youth activities, adult citizens, and in what I think is one of the most striking innovations in the case, unborn fetus, represented by their parents. The case was therefore not brought on behalf of an existing generation, but on behalf of those who had not yet been born. The legal target was Korea's Carbon Neutrality Framework Act, which set the headline commitment of net zero emissions by 2050 and a 40% reduction below 2018 levels by 2030, but which contained no binding quantitative targets for the intervening period of from 2031 to 2049. The petitioners argued that this gap in the legislative framework violated the constitutional right to a healthy environment under Article 35 of the Korean Constitution. The outcome was clear. The court unanimously held that the absence of any binding midterm pathway was unconstitutional and ordered the Korean National Assembly to legislate binding reduction targets from 2031 through 2049 by February 2026 this year. At that same time, and this is important, the court upheld the 2030 target as constitutionally equitable. The court corrected, it did not override. The doctrinal contribution of the decision rests on 2 interlocking pillars. The first is the prohibition of insufficient protection. The principle developed in German constitutional law and now transplanted into the Korean context, the Korean Constitutional Court confirmed that constitutional rights can be violated not only by excessive government action, but also by state omissions. The complete absence of a regulatory framework for from 2031 to 2049 period failed the minimum level of constitutional protection required by Article 35 of the Korean Constitution. The second pillar is intergenerational justice. The Korean Constitutional Court held that Article 11 and Article 35 of the Korean Constitution, the equality guarantee and the environmental right, must be read together to protect future generations, drawing explicitly on Germany's Neubauer decision of 2021. The Korean Constitutional Court applied the concept of intertemporal freedom, the idea that present-day emissions exhaust the national carbon budget and therefore thereby constrain the liberty of citizens who have not yet been born. This makes this Korean Constitutional Court case, the first constitutional court in Asia to fully constitutionalize the climate mitigation obligation. I want to turn now to the conditions that made this litigation succeed, because I think these are directly translatable to the question of how state duties to future generations can be operationalized elsewhere as well. 4 conditions stand out. First, petitioner diversity. By including unborn fetus alongside youth and adult petitioners, the litigation gave the Korean Constitutional Court a powerful moral anchor. It was adjudicating not just for those present in the room, but for those not yet capable of speaking. Second, right-based framing, anchoring the claim in Article 35 of the Korean Constitutional Court, transformed climate governance from a matter of policy preference, where courts are rightfully differential, into a justiciable constitutional obligation. Third, scientific grounding. IPCC AR6 data and the Paris Agreement provided the Korean Constitutional Court with an objective external yardstick. The Korean Constitutional Court did not need to substitute its judgment for the legislatures on the content of climate policy. It only needed to confirm that a complete absence of interim targets fell below any defensible threshold. Fourth, deference correction balance. By upholding the 2030 NDC while striking only the legislative gap, the Korean Constitutional Court avoided the charge of judicial overreach and thereby strengthened the legitimacy and durability of the remedy. This chart illustrates the emissions trajectory that divided the Korean Constitutional Court. The government annual reduction plan from 2023 to 2030 was heavily backloaded. Modest cuts in the early years with a dramatic steepening in 2028, 2029, and 2030. 5 of the 9 justices found that this convex profile imposed unfair burdens on the years immediately preceding 2030 and therefore violated constitutional fairness standard. This view, however, did not prevail because it fell 1 vote short of the 6-justice supermajority required under Article 113 of the Korean Constitutional Court to make a statute unconstitutional. But the split itself is instructive. It signals that not only the existence of targets, but the temporal distribution of the reduction burden is now a live constitutional question in South Korea. The most direct measure of the Korean Constitutional Court decision's practical impact is the government response. On 11th November 2025, last year, at the National Cabinet meeting, South Korea confirmed its 2035 nationally determined contribution reduction of 53 to 61% below 2018 net emission of 742.3 million tons of CO2 equivalent. This target was formally announced at COP30 in Belém, Brazil. The range is not arbitrary. The lower bound of 53% represents a linear reduction pathway consistent with achieving 2050 carbon neutrality, effectively the minimum that the constitutional standard implies. The upper bound of 61% reflects the latest IPCC AR6 recommendation. Crucially, the government press release explicitly acknowledged that the target was calibrated to meet the Korean Constitutional Court standard. Korea's fair share must be grounded in the scientific fact and international benchmark. Sector-by-sector measures accelerated renewables in the energy sector, green hydrogen, and low-carbon manufacturing in industry are now being designed to deliver the headline figure. The lesson here is simple and powerful. Judicial accountability can drive policy ambition. Let me close with 3 lessons that I think the Korean experience offers for the implementation of the ICJ advisory opinion. The first is that a right-based framework unlocks justiciability. The ICJ advisory opinion of 2025 confirmed that states owe due diligence obligation under UNCLOS and the UNFCCC and customary international law, but obligations stated in the international level must be operationalized at the domestic level. The Korean Constitutional Court case shows that anchoring those obligations in constitutional right provisions is the mechanism that make them judicially enforceable, and that courts, when properly anchored, will act. The second lesson is that temporal specificity is not negotiable. The Korean Constitutional Court did not strike down the 2050 net zero goal. It struck down the absence of midterm milestones. States that have made long-range pledges but have left the interim pathway vague are in constitutional and arguably international law terms in a legally precarious position. The obligation is not just to declare a destination, but to legislate a path. The third lesson is that science plus international standard equals the judicial anchor. The IPCC and the Paris Agreement gave the Korean Constitutional Court the external reference point it needed to act without simply substituting its policy preferences for the legislators. ICJ advisory opinion implementation will require the same architecture at the national level, scientific evidence translated into justiciable threshold embodied in legislation and reviewable by court. In conclusion, the Korean Constitutional Court case is the first Constitutional Court decision in Asia to fully constitutionalize climate mitigation obligation. It establishes that legislative omissions, not only legislative acts, can violate fundamental rights, that the right of unborn future generations carry constitutional weight, that temporal specificity in emissions pathway is a constitutional requirement, and that judicial accountability can translate into enhanced policy ambition. I hope that the 3 doctrinal innovation of this case, the prohibition of insufficient protection and intergenerational justice, and the science-anchored fair share standard, can serve as useful conceptual tool for those working on the implementation of state duties to future generation in this forum. Thanks so much.
Thank you very much, Woo-jung. This was very comprehensive, and I think an illustration of the previous presentations as well. I think I really liked as well the parallel conclusions that you and Alina and Aishwarya arrived to, that rights-based frameworks, but also science and international standards are really conditions for success.